Welcome back to your Immigration Compliance Corner. My name is Emily Brown, and I'm the founder and principal attorney of Elevate Justice U.S. Immigration Law. And every Wednesday, we host this live to go over the latest topics in immigration compliance. We are a private immigration law firm that specializes in immigration compliance and federal litigation. Today's topic is what to do when your company receives a notice of inspection for your Form I-9s from ICE. So let's say ICE shows up at your business and hands one of your employees a notice of inspection. Now people are tense and they're starting to panic. So what do you do? Before we dive in, everything that I'm sharing today is for general educational information only. It is not legal advice. Immigration law changes frequently. So for guidance tailored to your business, be sure to consult a qualified immigration attorney. Just for context, there are generally two ways that your company could receive a notice of inspection. First, ICE could come to your company and hand deliver a notice of inspection. So you want to make sure your employees are trained on what to do in those situations. You want to make sure that they're not just automatically handing over your Form I-9s to the ICE officers, that the right person is notified immediately, whether it's managers or the owner of the company. You want to have that process already worked out before ICE shows up with a notice of inspection. Second, you could receive a notice of inspection via certified mail. So you want to have a process in place to make sure that your employees know that if ICE is sending something by certified mail, that the right person is then notified immediately. A notice of inspection generally has a very short window for responding, which is 3 business days. So you need that process in place quickly. So, step one, what are you going to do? You're going to read the notice of inspection and note a few things. First, you're going to note the deadline. Like I said, they only have 3 business days to respond, so you want to get that deadline written down right away. Second, you want to read what the notice of inspection is requesting. Understand the full scope. They're requesting your I-9s. They may request payroll records, list of employee names. If you have electronic I-9 systems, they're going to also request information from your electronic systems. So you want to make sure you know what they're requesting and what they're not, because you don't want to send them documentation that they're not actually requesting. Some common mistakes that I see when a notice of inspection is first received is that employers start trying to fix I-9 records right away. That's not something that you want to do unless you're working with immigration counsel. So, step two, you want to retain immigration counsel immediately. 3 business days is the default response, but a lot of times an immigration attorney can email ICE within the first 24 hours and request an extension. They're also going to do a scope assessment, figuring out what ICE is requesting and what they are not requesting. And then they're going to become the communication channel with ICE. And so having an immigration attorney representing you is going to change ICE's posture with how they're dealing with your company. The notice of inspection process is a legal process, so it's highly recommended that you have an immigration attorney guiding you along the way to make sure your company's rights are protected. Step three, you're going to gather, copy, and review your I-9 records. So you're going to pull every I-9 plus the supporting documentation that ICE is requesting, and then you're going to copy everything before submission so you know what you're handing over to ICE. You could do an internal review with your immigration counsel, and they could separate the technical violations from the substantive violations so that you can do some remediation work beforehand. Substantive violations are likely going to be finable right away, so they can also help you get an understanding of what your risk is. Your immigration attorney is going to work with you to decide what gets remedied and also what gets argued with ICE down the line. When it comes to good faith and fixing technical errors, I do want to point out that it's really important to make sure that you're doing internal audits before a notice of inspection even arrives. Because when you do an internal audit and you fix your technical errors ahead of time, that's when you're going to have the strongest good faith effort. If you receive a notice of inspection and then start correcting your technical errors, that's going to look like damage control, and ICE is less likely to say that that's going to be a good faith effort to keep your I-9 records compliant. Step four is when you submit the paperwork to ICE, and there's a waiting period. The review can take months, sometimes 6 months to a year, depending on the ICE log that they're working in. But during that process, you could receive some notices. So first, you could receive a notice of suspect documents, which is essentially asking you to verify the documents that the employees might have given you when you were completing the I-9, because it's not reasonably genuine to ICE's perspective. The other thing that you could receive is a notice of discrepancy, and that is when the information that the employee has given you to complete the I-9 is actually contradicting or conflicting with information that ICE or the government has on that that ICE has on that employee. So there's a discrepancy with the information. Each response or each notice that you could be given has a response window, and it's going to shape the final outcome of the audit. So you do not want to respond to these without your immigration attorney. Then step 5 is going to be ICE's findings. So there's a few possible outcomes. They could just issue a notice of inspection results, which is saying, okay, everything was fine. There was no errors. You're clean. You're good to go. The next one is a notice of technical or substantive violations. So if they issue a notice of technical violations, you're going to have a 10-day business window to correct those. For substantive violations, those are going to be not correctable and immediately finable. They could review everything, find some errors, and then issue a warning notice like, hey, we found these errors. You need to correct your practices. And they could give you a warning notice. And a lot of times, ICE might come back for a second audit. And then another one is the notice of intent to fine. So that is when they have found substantive violations that they are assessing fines for. When you receive ICE's findings, you want to work with your attorney to develop a strategy. If you are given a notice of intent to fine, sometimes your immigration attorney can negotiate with ICE to try to lower the fine amount. Or your attorney could appeal the findings with the Office of the Chief Administrative Hearing Officer, or OCAHO, which again is like a litigation process. So that's why it's so important to have an immigration attorney with you from the very beginning if that is the route that you end up needing to go. So, a lot of information here, but if this is an area where you feel like you want to be more confident before ICE arrives, I am going to be covering this topic in my upcoming HR I-9 compliance cohort. So, I've developed this I-9 compliance cohort for HR members or even for small business owners. It's going to be 5 live sessions starting June 23rd every Tuesday, and it's going to be taught by me. We're going to go over, actual statutes, regulations. We go over how to respond to a notice of inspection. We really go in depth in I-9 compliance so that you come out more prepared. You're also going to get live attorney Q&A with me at the end of every session, which is, the chance to speak to an immigration attorney about what you're actually seeing happening on a day-to-day basis. You're also going to get a bunch of downloadable tools that you can keep with you and start using right away. The way that I've designed this program is that so HR representatives or HR professionals can actually submit for self-reporting with SHRM and HRCI to get 5 educational credits out of this program as well. So I want to make this as valuable for you as possible, giving you information, but also that so you can get professional development from it too. So it was great to see you all again. My name is Emily Brown with Elevate Justice U.S. Immigration Law. If you want to learn more information about the HR I-9 compliance cohort, I'm going to drop a few links in the comments, one to our list to sign up if you're interested and you want to dive right in, or just to our website for some more information about the cohort in general. Also about the cohort, it's limited seats, only 15 seats. It's my intention to keep it very personal and intimate so that we can really get a lot out of the live Q&A session. So be sure to save your spot before June 23rd. Looking forward to seeing you next week. Take care, everybody.